I'd like to change the topic to indefinitely confined voters. As I understand the argument that you're making, it is based on the fact that there was some guidance that was issued on March 25th in Dane and Milwaukee counties regarding which voters could claim that status. And you are asking this court to basically toss the ballots that were cast after that advice was handed down. The problem with that I see is that there are people who were probably legitimately and in accordance with the law indefinitely confined. And so that would require the court to toss those ballots as well. I don't see anything in the record that would enable us to discern between the ballots that might have been cast not in accordance with the indefinitely confined statute and those that were.
And candidly, Your Honor, 6.86 sub 2 sub B is the statute on which we rely here for the clerks acting on reliable information in order to discern that very thing that you're suggesting. There was, as with other limitations in the recount statute, but particularly with regard to absentee voting, the statute makes certain assumptions and then requires certain actions precisely because of the extraordinary difficulty, if not impossibility, to later examine each and every voter for example, to determine whether they committed some type of fraud or other irregularity. So the statute makes certain presumptions. So our conclusion here was simply that as best we could, we've identified those people whom the clerks should have in fact acted as, we'll call them sentries for, looking into them. And correcting it and making sure that they had not done that. They did not do that as to these particular voters, and that's the reason we selected them. But Your Honor points to a very difficult problem.
Counsel?